Madam Speaker, I rise to second the reading of the bill shortly titled Plea Negotiations Bill 2024. Madam Speaker, prior to my sojourn here in this honorable house, I practiced as a legal practitioner in the criminal court, where I championed the cause advocating for fair treatment of accused persons. And so this afternoon, I want to express my unequivocal support for this bill. I do so for a number of reasons. I understand firsthand the complexities of our criminal justice system and the importance of ensuring that justice is not only done, but as we always say, is seen to be done. And done efficiently, done fairly, and with the full consideration of the rights of both the accused person and, of course, the victims. So one of the criticisms leveled at plea bargaining is that defendants may feel pressured into accepting plea deals to avoid harsher sentences at trial. And whilst I understand this concern, Madam Speaker, this bill contains critical safeguards against coercion. Every plea agreement will be subjected to judicial oversight, ensuring that an accused person is not entering into a plea out of fear or undue pressure. As the mover of the bill indicated, the judge will have the discretion to reject any agreement if it appears unjust or coerced. There might be some arguments as well, Madam Speaker, that innocent persons may plead guilty to avoid the risk of a more severe sentence after trial. While this is a reality of any justice system, it remains an individual choice. Our justice system is built on the principle that an accused person must be informed of their rights. This bill requires, in that vein, that the court ensures that any accused person who pleads guilty is doing so voluntarily and with the full knowledge of the consequences and with legal representation wherever possible. This ensures, Madam Speaker, that no one is misled or tricked or coerced, possibly, into a guilty plea. Another common concern is that plea bargaining may lead to disparities in sentences, where two defendants charged with similar crimes receive different sentences based on their negotiation skills rather than on the merits of their case. However, as you should be aware, Madam Speaker, our jurisdiction follows the sentencing guidelines established by the Eastern Caribbean Supreme Court. These guidelines provide a clear framework ensuring fairness, transparency, and proportionality in sentencing. This mitigates the risk of arbitrary sentencing and ensures consistency across cases. Another argument that may be made is that plea bargaining encourages defendants to waive their constitutional right to a fair trial. As fickle as it sounds, it can be raised. However, Madam Speaker, the right to a fair trial includes the right to decide whether to go to trial or not. This bill does not force anyone to waive their rights. It merely provides an additional option for accused persons to resolve their cases more efficiently if they so choose. Justice should not be about forcing trials where they are unnecessary, but about ensuring that every person accused is afforded the choice that best serves their interests. In doing the research, some concerns in relation to this bill as well raised about plea bargaining agreements negotiated behind closed doors. The arguments are that this reduces transparency and accountability. However, this bill before this House ensures that no agreement is final without judicial approval. Judges will therefore have the power under this bill to reject any deal that is not in the interests of justice, and I think the mover of the bill referred specifically to this section in the bill. This safeguard determines and guarantees that no backroom deals can undermine the integrity of our justice system. Madam Speaker, there is also the argument that plea bargaining reduces scrutiny of cases, including the conduct of law enforcement officers and the strength of the evidence. But this bill does not eliminate the requirement for judicial examination. The court must hear from the accused before accepting any plea agreement, and the court has the power, as said earlier by the mover, to reject deals where necessary. This ensures that due process is followed and that cases are resolved at the end of the day in a fair manner. Victims of crime, and like I started by saying, I support it because it ensures justice for the accused and for the victims. And so victims of crimes must have their voices heard in the justice process. Some critics argue that plea bargaining undermines justice by allowing offenders to receive reduced sentences. However, Madam Speaker, this bill explicitly provides for victim impact statements. And I was looking at the section in terms of how the court should embark on the exercise of taking this statement from the victim, and this is in section 15. It says, subject to section 16, before a plea bargain is concluded, the Director of Public Prosecution shall permit the complainant, and that is the victim, or the DPP's office who represents the victim, to make representations to him in writing and may take such representations into consideration in concluding a plea agreement. Where a plea agreement is concluded, the Director of Public Prosecution shall, unless otherwise required by the compelling reasons in the interest of justice, as soon as is reasonably practicable, communicate with the complainant in respect of 1, the substance of and reasons for the plea agreement, and 2, the entitlement of the complainant to be present when the court considers the plea agreement. So clearly the victims of crime will have their voices heard in this process, and the court is obligated by law to consider any evidence from a victim impact statement in determining what sentence would be appropriate. This means victims can express how the crime has affected them, ensuring that their perspectives play a role in the sentencing process. Another concern is that victims may feel excluded from the plea bargaining process, leading to dissatisfaction and a lack of closure. Madam Speaker, this bill ensures that victims can make representations before an agreement is concluded, and that is provided in section 15. Their impact statements will be considered by the court, allowing them to participate meaningfully in the justice process. And so I did indicate that my contribution would be brief. So I'm going to conclude that this bill represents a balanced, pragmatic, and necessary step towards a more efficient and just criminal justice system. It provides safeguards against coercion. It ensures fairness in sentencing. It respects the constitutional rights of accused persons. It increases transparency and upholds and respects the rights of victims. It is a bill that is not only defensible, but essential, as the mover indicated, for a modern justice system. As a former defense counsel, I have seen and heard the woes related to delays in the system, inefficiencies and injustices that can arise in a system that does not allow for well-regulated plea negotiations. In fact, the system already makes provision for this. If I could remember what it's called, the Goodyear Direction, good year direction where a defendant or person accused can actually, before taking a plea, indicate to the court that they want to make a good year, they're requesting a good year direction before trial and before they actually plea. On that exercise, the court is then determined, the court would then give an idea as to the type of sentence that is likely to be imposed at the end. Now, at the end of that exercise, then the victim, the defendant, forgive me, is then required to take a plea. So this is not anything new. It is structured, it is clearer, and I think the Goodyear direction came out of, is it the case called Goodyear? Yes, so I think from the case law, we are moving forward in terms of introducing statute. So, like I said earlier, I wholeheartedly support this bill, and I urge this Honorable House to support it in its entirety as well. Let us give our courts and the persons who work in the administration of justice the tools they need to resolve cases fairly, efficiently, with justice at the forefront. And so with those brief words, Madam Speaker, I wish this bill safe passage through this Honorable House.